Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me tonight I've got John Karantzis, an accredited law specialist in workers' comp in a law firm. Good evening, John.
Hi Tony, hi viewers.
And a public liability insurance lawyer at a law firm and partner, Nuncio Tartaya. Good evening, Nunc.
Good evening, Tony. John, viewers, welcome.
Viewers, tonight we're very fortunate that the Juries Commissioner Paul Dorr has let us film in his office. Now, he'll be back just after the break.
But Tony, before we get into the jury system, what's in the news?
Well, viewers, there's been a lot of stories, a lot of tragedies. It's just been one thing after another. But firstly, John, this is something that's right up your alley.
Yes.
We're talking about the case of Grocon and the Aussie Sign Company.
Yes.
The wall that collapsed and killed 3 people, brother and sister, and a doctor. The two firms are being charged, and they've got 9 charges against them, each carrying a maximum of $1.3 million penalty.
Yes, Tony, the Victorian Workcover Authority have laid charges against Aussie Signs, a firm in Sandringham that were a subcontractor, and Grocon, alleging very serious breaches of the Occupational Health and Safety Act, Tony.
John, these charges are against the company themselves.
Yes.
Is that correct?
Yes.
Not individuals?
No, not individuals, Tony.
Okay. Nonce,
Yep.
3 people killed, a host of other people witnessed these deaths.
Yep.
A lot of other people witnessed them either firsthand or via the media. Are there any potential claims to come out of this?
Look, there's potentially a lot of civil claims arising out of this incident, and John and I were talking offset. There was a worker who was involved at the time of the accident,
yes.
So that goes through obviously the work cover system. But the other 2 that unfortunately passed away, that'd be a public liability claim. And look, if charges are laid and they're found guilty on those, it's really an assessment.
The 2 kids, they were Melbourne University students, Nuncio, walking along Swanston Street in Melbourne, and then this wall falls upon them. Just one query. Would there be a potential claim against Melbourne University, Nuncio, on the basis that Melbourne University would have been aware that university students use this walkway all the time?
It's a bit speculative.
Look, I think it's unlikely, John.
Foreseeability is an issue.
And considering when you look at the extent of the charges laid, Grocon had control of the site. They knew, what needed to be done. They should have done risk assessments on the hoarding and on the wall, and they didn't do so.
So Grocon and Aussie Signs are really in the gun, aren't they?
And hence the charges. So.
Really, it hinges on that, Nonce. There was a lack of risk assessments, a lack of a plan to do with, loading, wind loading, all this sort of business.
It's taken over a year for Workcover to finally charge these 2 firms. The court process is a slow process, isn't it, Tony?
It's very slow.
It'll probably won't reach a hearing till maybe late 2014 or early 2015.
It depends on whether they intend to plead guilty or not, which is...
Well, that too.
Yeah, we don't know. I mean, we'll have to come back to this, viewers, so stay tuned. Family violence, we've definitely got an epidemic on our hands, haven't we?
Yeah, we definitely do. And look, I think that we've had some serious campaigns on smoking, road transport accidents. I think it's time now that domestic violence is the next one. It's getting
Nonce and Tony, we need to protect the kids. We need to protect not only the kids and females against these aggressive perpetrators.
Well, in the last week and a half, we've had 2 females killed. We've had 2 young sisters killed. We've had... It's just never ending.
Is it simply a case, Tony, of more money? Is that needed?
I don't know, but I'm almost inclined to think it seems to be simple and not too hard to get an intervention order, you go to the police, they send you across the road to the magistrate's court, you get your intervention order, more often than not, the other party doesn't appear.
But isn't that a waste of time?
Well, without the order, the police can't attend because they've got no basis to attend.
Are these orders enforceable in any event, Tony?
They are enforceable. The only problem is there's so many of them, and you almost need a particular unit set up just to deal with intervention orders.
My problem is, I think at the moment the way it's being run is it's a one-size-fits-all campaign, and that doesn't work in these situations. There's so many different isolated
You need a
incidents.
specialised unit, I think.
Yeah, and that's why, look, I think John's right when it says it does come back to funding. They donated, or they put $16 million forward in 2012. They needed to completely throw...
So we want the Liberal government of Victoria to put in a lot more money to develop a specialist unit to deal with this.
I think a specialist unit would be the way to go.
Okay.
In fact, they should almost arbitrarily go and attend upon various people who've got orders against them just to see how they're conducting themselves, to see if they're breaching orders, to see if they take them seriously. Because at the end of the day, I've never heard of anyone with an order against them being approached by anyone.
And it's even been raised, maybe going to, the case of victims going to their homes beforehand if there is, say, restraining orders put out against them, proper locks on the windows, doors, things to make sure that they feel safer at home. They're just not being done at the moment.
And one of the problems too, if you have a look at these orders, they say you can't approach 200 metres. Now, how technical is it?
Yeah.
If you're 150 metres away, you ring up the police. By the time they get there, the person's outside that range. It's problematic, don't you think?
It is, Tony, and children are involved also. And that makes it even more...
A lot of innocent people are getting... children are getting killed.
The tragic death of Indiana and Savannah a couple of weeks ago was horrific.
I think we should do an episode just on that alone.
Yes.
Yeah. And also what, consequences flow from it, not only from a criminal perspective, but also civil.
Yeah.
Let's keep moving. Because we're talking about juries and the juries commissioner's role.
Yes.
There's this interesting case of this fellow in the States, a Kansas man, who's up on a murder charge, and guess what he's got inscribed on his neck, John?
Tell me, Nonce.
Murder.
No.
Murder.
And the defence counsel, defence counsel saying the jury shouldn't be allowed to see the tattoo because it's prejudicial.
Oh, you think?
But what would he have thought of that before he inscribed it? And I mean, is it almost him saying, I would have arrested him before he committed any crime, because it's almost him saying, that's what I propose to do.
I mean, the problem is, Tony, it is prejudicial to a jury, isn't it?
Yeah, but why would you have a murder written on your neck? Well, I'm not talking about a little inscription. These are big, bold letters.
People have everything on the tattoos these days.
The double-edged sword, though, is that the county sheriff there doesn't want to let him go to the tattoo removalist.
Well, the court would order otherwise, wouldn't they?
Yeah, they're going to have to go to court.
Wear a high neck.
But let's say, all right, let's say this. Wouldn't the prosecutor in cross-examination say, do you have a tattoo on your body? And what type of tattoo would you have? And he'd have to disclose under cross-examination that, yes, I've got murder as a tattoo.
Yeah.
How can you hide that? You can't.
Yeah, but the thing is, he's the actual offender, John.
Well...
this Daniel Morecambe murder case in Queensland.
Oh, yes.
They attended the scene of the crime.
Yeah.
And there was a note there.
There's a note left by a victim, and the jury saw it, and effectively it was a basis to try and have a mistrial.
But what's the note say?
The note basically
Say
said, Tony, that whoever did this should be put away in jail.
In fact, the note said that the person that's on trial should be sent to jail, convicted.
Yes.
Which, I mean, is almost...
It's prejudicial.
John, thanks for coming on board. Nonce,
Thanks.
We've got the
Thanks,
Juries
guys.
Commissioner. Viewers, stay tuned. We're going on a sponsors break. Back shortly. Viewers, welcome back to the show. We're doing the second part of our two-part series on the Juries Commissioner and juries in general. We're in Paul Dawes' abode. Thank you, Paul.
Just an office, but yep.
And thanks for coming back on the show
Thank you
again
for
this
having
week.
me. Thank you for having me.
Paul, the first question I want to ask you is this. There's a perception out there that the majority of people that go on juries are retirees, unemployed, and people that are getting towards
pension
the end
and
of their
others.
career. Yes, yes.
All I can say to that myth is that we interviewed jurors last year, so those that are presented to serve on a jury and those who actually served on a jury. And those three groups made up less than 5% of the people who were here and served. It was approximately 25% were professionals, and another 25 or 26% were public service, and then a smattering of others across the board. So I think it's a myth that lawyers and others might perpetuate. But
So Paul, anyone that's on the electoral roll
Absolutely.
is eligible to serve on the jury.
if you're on the electoral roll, you may get a questionnaire from us, and then you answer that questionnaire and determine whether you're available or.
Tonight, viewers, we're going to be dealing mainly with the issue of social media. How does that impact on jury's deliberations? Now, Paul, your own personal view. We've got Facebook, we've got Twitter, we've got Yahoo, YouTube,
Google.
never ending.
Yeah.
How do you think that impacts on juries?
I think for the most part it doesn't. I think for the most part jurors hear the messages we give them, and certainly hear the messages judges give them, and they do the right thing. But that being said, I think courts and jury managers will have to start to turn their mind to how we can better communicate our message that you can't use it, because the days of not going to your iPhone immediately are over. I've got two children who are glued to them. So the day of a good argument where I tell you something and you tell me something and we agree to disagree is over. People look it up.
We're in a modern age,
Absolutely,
Paul. It's a world of instant communication.
Instant information as well.
Everyone does a Google search on any topic. And you'd think, jurors would be tempted, wouldn't they?
They would be tempted. I can't guarantee I can't deny that they would be tempted. But we are very explicit, and so are the judges when they do their charge, when they direct the juries, that they are in breach of the act if they do their own investigation, their own experiment, if they visit the scene of the alleged crime, if they do any of their own investigation, and that includes using the internet to do it, they are in breach of the act, and they could find themselves in the magistrate's
Paul,
court.
that brings us back to the fundamental rule that the jury in a case has got to judge a case based on the facts that are actually before the court.
Absolutely.
They're not allowed to use any extraneous materials or anything they get by third parties or to social media.
I say to jurors, you're not the investigators.
No.
There are enough, and I don't think a judge wants 12 more investigators in the courtroom. You listen to the facts and you make your decision based on those facts.
And John, it's just bad luck or unfortunate to one of the parties if one of the counsel fails to introduce material that is relevant.
Well, it's part of the common law system. You have two sides against each other.
Yes.
Now, they're supposed to bring as much detail and evidence in support of their case possible.
Well, it's adversarial, so effectively it's what you introduce into the proceeding. A lot of cases too, to the public, you'll find that lawyers don't introduce material because they don't want the jury to know about it.
Yeah.
So they deliberately keep it away from the jury.
And that's why a judge will say to a jury, you just listen to what's presented. Any questions, you can ask the judge. If you want any clarification, you want something repeated, you can ask the judge.
There's been a lot of instances, Paul, where jurors have been, I've read about it, and not that I've had personal experiences, where jurors have gone onto Google to work out what is a wrench.
Yep.
I mean, they should really ask the question, shouldn't they?
Absolutely. Look, the only way to say something serious is to say it in a joking way. I often say to jurors, Google dumb things jurors have done, and you'll see a list of things that people have done that were not the brightest thing to do.
Well, juries probably don't know that they're entitled to ask questions if they're unsure.
And I think they're in unfamiliar circumstances, so they may be afraid to ask questions. Judges do bend over backwards to tell jurors that if you've got a question, you can ask me.
What's sub judice mean?
The issue, Tony, is when there is media speculation, there is information out there in the public domain prior to the hearing.
So effectively, you've got a criminal prosecution that's just been launched.
Exactly.
Or a civil matter that's just been commenced.
Yes.
And one of the parties goes to the media and discloses information.
There's information out there that is in the real world and it's not part of the court process.
And Paul, the judges don't particularly like that. They don't like people disclosing information about cases before they're decided.
No, and jurors are under very strict instructions that they're not allowed to speak with anybody about anything that is not. Well, they're not allowed to speak to anybody about anything.
And they're instructed to ignore all that information, aren't they?
Yes, absolutely.
The court does not want, Tony, any outside influence.
Yes.
The court only wants the jury and any arbiter of the fact to hear what is said within the court.
Although they do say that your own personal, you bring your own personal education and background into it.
Well, I think that's the beauty of the jury system,
Yes.
is that you do bring community standards, you bring community expectations. You as a group, you come together and you reflect what the community values and
Well, that raises my next question to you, Paul. Just about every state in the country has done away with juries in civil trials.
Yes.
I think Victoria's the last of the states.
I think it is.
Do you believe that there's a role for juries in civil cases in Victoria?
I think that in civil cases, you might bring a bit more emotion into particularly the awarding of damages. I think that's the only place where you might want to look at it.
Yes.
The fact that the jury will deliver a verdict not beyond reasonable doubt, but on the balance of probabilities, one way or the
In a
other,
civil trial.
might be okay. But this idea then that they also have an influence or a say on what damages might be awarded, that might be a problem. But I would say my job ends at the courtroom door.
John, I'm going to ask you your opinion, but after the sponsors break. So viewers, stay tuned. We'll see what Mr. Carrance has to say about this issue. Viewers, welcome back to the show. John, I asked you the question before the break. What is your position in relation to jury trials in civil matters? Because I do agree the jury system does work in criminal matters because it's community standards and the jury brings their own personal experiences and it gives you a perspective on what the people out in the street would like to happen.
And that's where I come from, Tony. It gives a member of the public the opportunity to provide justice to, in my case, an injured worker, Tony.
Okay.
It brings justice against people that have no prospect of justice otherwise.
Well, Paul, I'm against juries in civil matters because of the length they bring to a trial.
Yep.
You know,
That
I
is a
find
problem.
that cases, we had recently a case where we're trying to determine who was driving the car. The estimate given to the court was 7 days and it ran for 20 days. And that was just on the issue of who was driving.
And that was because there was six extra people in the courtroom.
People.
6 jurors in a civil trial in Melbourne. Now, I was recently in New York, Tony, as you know. A civil case there's 12 jurors, Paul.
Right. Yeah.
12 jurors. Now, and as you know, there's an elocution process before the jury is actually impanelled. What do you think of that system where literally you are cross-examined as to your beliefs and whether or not you can get onto the jury?
I'm not a big fan of it. Look, I have to declare that I've never worked or practiced or did anything other than visit New York as a tourist. But I do like the Victorian system that takes people randomly. We do excuse people and defer people when necessary. But this idea of interviewing people,
Yes. Or cross-examining them as to their beliefs, their background.
I'm not a big fan of it.
And
But there's
jury sampling?
I think there's a whole industry in jury sampling, isn't
If
there?
we're worried about adding time to a trial, this is just going to blow them out completely.
I mean, I will say, and this is just to plug our service, is that it's no longer or quicker to get a panel into court, whether it's civil or criminal. But whatever happens in the courtroom that then slows things down. Is, I think. For
Tony, could I ask you
Yes.
if the jury system was just as fast as a single judge determiner, would that be okay?
I'd be a lot happier. I think the jury's burdened with too much stuff that doesn't really concern them. I think that the parties are too concerned about playing up to the jury. They call for a recess or a break in proceedings more often than not.
All right.
To have a debate a legal point so that the jury doesn't see what's going on.
There is the issue of barristers playing up to the jury.
They do play up to the jury.
Playing
It's a
up
fact.
to their prejudices.
Exactly. That's my concern.
That's a concern, isn't it?
And
you and I have seen that, haven't we, Tony?
Yeah, we have.
And we've seen really smart Queen's Counsel and Senior Counsel really play to the prejudices
They're playing
of
to
the
the prejudice
jury,
of a jury.
and really trying to put aside the facts of the case to get a result.
Exactly.
But isn't then the responsibility of the judge to try and get that out?
It is, but it's hard because then if they interrupt too often, Paul, then there's the issue of bias and not giving the parties a fair trial.
True.
Paul, let's get back to this. You've been a jury's commissioner for how long?
A couple of years, 2 years.
And you're obviously enjoying your role.
Loving it.
Looks like it.
Loving
Yes.
it. Yeah.
And the system's running as good as you've seen it?
Yeah, look, there's always room for improvement. We've got two priorities. One is to get panels into courtrooms as quickly and seamlessly as we possibly can, and we've got to do that without inconveniencing or minimizing the inconvenience to the citizens. And we acknowledge every day that it's an inconvenience. You mentioned earlier, employers carry a great burden.
Yes.
Citizens have to turn their lives upside down, put things on hold, but
It's a civic duty.
I think it's a civic duty, and more we're seeing it as a civic right.
Yes.
We've got now people saying, I've got a right to do jury service, and you have to make it happen. And the system is not always inclusive. We talked about it outside the break, but at the break, the first question on our eligibility questionnaire is, do you speak English well enough
That
to do jury
would cut
service?
out a lot of people.
It does.
So,
It does.
so anyone that does not speak or read English
Can't understand English well enough to get by, as in the same way you want them to speak English or understand English in the workplace or in a social setting.
yes.
They don't need to understand, nobody understands legal terms or forensic terms or medical terms.
So
we don't
you're
expect that.
literally you're excluding could be 10% of the population.
I don't know what it is, but the answer is yes. We people who are visually or visually impaired
Deaf.
or deaf are excluded. And
So if you've got a defendant, Tony, that is of a multicultural background who doesn't speak or read English,
Yes.
is he going to be tried by a jury of his peers?
Well, that's an interesting concept because
if I got
He
tried,
won't.
I mean, well, that argument is that even if I got tried, I understand English, but 12 people aren't from Canada. I think you get a cross section of people that just gets close enough is good enough. I don't
Yes.
think we ever expected you were going to have 12 Canadians.
But that's that's the beauty of the jury system.
Yeah, I
isn't
think
it?
it's a cross section, and those people who come from other countries bring their values and standards in, and they're part of our community, and you would expect them on the jury. But you wouldn't expect 12 people who would be absolutely in sync with
No.
the views of the
Paul,
accused.
I think that you can't do without a jury in criminal trials because
No, I
I'm
agree.
watching this Oscar Pistorius trial. I think it's a pretty heavy burden on one particular person, judge, to decide the case.
Oh, yes.
But in civil trials, the other main reason I'd prefer to run with a judge alone is I've got a lot of confidence in the judiciary. I think they're very learned, experienced. They've been at the bar for many years. Even the ones that haven't been at the bar, they've been around long enough to know what's right and wrong and what community standards are, which is important.
Yeah.
But they also give reasons in writing. I think that's important.
Yeah.
The parties do want to know, why did I win or lose? At the moment, the way the jury system is,
Oh, yes.
they don't give a reason.
Yeah.
In fact, you can't ask them a question.
Yeah.
In a civil case,
And if I
Paul,
were,
it's simply yes or no.
and if I were in your shoes, I would find that pretty frustrating for the next time you have to go into
It's
court.
great when you get yes and $1 million plus,
Yeah.
but it's not great when you get a no.
But John, I don't want the public to think they're getting $1 million every day because it doesn't
Not
happen
every
too
day.
often.
I've had 2 jury verdicts that are in excess of $1 million, but
That's a rarity.
doesn't occur.
That is a
no,
rarity.
It's a rare.
Paul, I really appreciate you and your office giving us the time and also exploring the court confines and seeing where the jury sit and what they do and everything else. I really thank you for that.
No,
Is there
it's
anything
good.
else you'd like to add?
No, I'm just happy that you were here. We do our very best to let the community know what work we do and the important work we do. So any opportunity I get to do that is always welcome. So
Thank you.
I want to thank you both for coming to my office.
And viewers, thanks for watching. Go to our Facebook and Twitter and give us any comments you'd like about the episodes that we've just shown. And also stay tuned for future episodes and always remember to stay safe.